Your spouse cannot access your rental properties when you pass away, even if they need the cash flow from those rental properties to be financially stable, or they need to sell those rental properties to generate cash to be financially stable. They don't have the ability to access those rental properties until the probate process is nearly over and those rental properties have been distributed out to them. And so when you have the rental properties in your personal name, even if you co-own them with your spouse, your portion of the ownership will have to go through the probate process before it can be distributed out to your spouse, and they can take over the ownership and control over that rental property. And so you have a couple different options on how you can set up your estate planning so that your rental properties will definitely go down to your spouse. And so the first one is going to be if you have them owned as joint tenants with rights of survivorship and you co-own it with your spouse, when one of you passes away, your half of the rental property would go directly down to the surviving spouse. If you have a will, you can outline that your spouse will get all of the rental properties, but those rental properties will have to go through the probate process before they can take over the ownership of those properties. Another one is going to be setting up a revocable trust and putting the rental properties inside of it. That will allow the rental properties to stay in the trust when you pass away and avoid the probate process, and then the spouse can use those assets, if they are the trustee, to take care of themselves. Or you could appoint another trustee to take care of your surviving spouse with the assets inside the trust. And then when your surviving spouse passes away, you pass those assets down to your kids and avoid the probate process altogether.